I'm William Underwood, and this is Rich Tyler, and we're going to be talking about coming to America, international arbitration, and its influence on domestic arbitration and some of the increasing impacts that we're seeing because of that. And so, just at a high level, our agenda for today, we're going to talk about kind of thematically, when is an arbitration international? What are some tips, tricks, and things to keep in mind when you are drafting your arbitration clauses, particularly if it is in an international context or may indeed be international. We're going to briefly talk about some of the components of an international arbitration and how those differ from traditional domestic arbitrations and the impacts that may have in the decisions that you may need to make. And we'll kind of wrap up generally with a discussion of the merits hearing itself, because it is different in an international arbitration context, and the award itself. And again, the creeping influence and impacts that we see in domestic arbitration from the increasing use of international arbitration.
So arbitration is a little bit like Roy Kent. He's here, he's there, he's every. Fans of the show can finish the thought. Arbitration has been commonplace in construction since the beginning. If you go back, the first set of AIA general conditions written in 1911 contain an arbitration clause. The thing I think that is different these days is that I have seen over the last 10 or 15 years a huge uptick in the number of arbitrations, but also arbitrations that involve what I will call non-American rules, non-AAA rules, not JAMS proceedings, things like that. And I think a big factor in all of that is the way construction has gone global over that same period of time. As Chad was talking, people are buying modules in Mexico. They're having fabrication work done in Malaysia. They're buying vessels from this country and that country. And what you see in the literature is that people who are not from the US are absolutely terrified by the prospect of being in litigation in a United States court. They really also don't like the American Arbitration Association because it has the word American in it, right? And they're worried that they're going to get some American arbitrator, and this American arbitrator is going to allow all sorts of discovery, and they don't like that at all. And so what you find is that with these contracts with overseas entities, there is a focus on rules, particularly the International Chamber of Commerce, that are driving the arbitral process. So a little bit about the pros and the cons of arbitration with a little flavoring of the international, and I'm going to start with the cons. People don't like arbitration typically because there's no appeal. The arbitrators issue their ruling and you're stuck with it. There's also the expense of the arbitration. You've got to pay an administrative fee to an institutional provider, and then the arbitrators themselves, they have pretty hefty fees depending on who you hire as an arbitrator. I had one 15 years ago, 3 arbitration panel here in Houston, and the 3 arbitrators each were north of $700 an hour. So the burn rate for that panel was $2,100 an hour. On the pro side, you avoid foreign courts and procedures, and particularly enforcement issues. There's no treaty for the enforcement of a United States court judgment in another country. And I had one case involving a Chinese entity, and the lawyer on the other side kept saying, well, you can get your judgment, but good luck going to China and getting it enforced. Another reason that you look to arbitration is for expertise and qualifications of the decision maker. I was telling somebody earlier, I had a case where we had a very fine, great, highly regarded U.S. District Court judge, and she bounded into the pretrial conference, and she said, you know, this is great. I've been on the bench for 15, 20 years. And she says, I have never had a construction case. I'm so excited that this is happening. A week later, we had a voluntary submission to arbitration. With an arbitration, you get to define, limit, and perhaps avoid discovery. You typically get a faster resolution than you would in a court. And probably the most significant feature of arbitration is that there is a treaty for the enforcement of arbitration awards.
Yeah, and that brings us to our next slide, which is about the 1958 New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. I'm sure you've all read it front to back. But as Rich said a second ago, there really is no treaty on the enforcement of U.S. court awards abroad. But the 1958 New York Convention really altered the game in terms of international arbitration. It suddenly gave validation to international arbitral tribunals because the signatories to this convention, of which there are about 172 in various forms and fashions, and it includes most of the developed world, they signed on to the convention, and essentially what it does is it requires all the signatories to recognize and enforce international arbitration awards. So now all of a sudden you can get a group of people in a conference room, arbitrate a dispute, and take that final award to virtually any corner of the world and have it enforced. And that is a game changer. And so looking at these articles here real quickly, just to put a bow on this, Article 1 requires the recognition and enforcement of international arbitration awards. Article 2 requires that signatory states not only recognize and enforce the awards themselves, but the actual underlying arbitration agreements as well. And Article 3 says that signatory states shall recognize arbitral awards as binding and enforce them. And to that end, the requirements for the enforcement of that award cannot be more complicated or expensive than those for your own domestic arbitration. So you can't disincentivize the use of an international arbitral tribunal by making it harder to do anything with that award once it's in hand. So again, you can't really talk about international arbitration without at least a tip of the cap to the 1958 New York Convention. And finally, and I think importantly as well, the convention provides for a series of enumerated reasons for non-enforcement of an arbitration award as well. And I won't go through all of these in great detail, but essentially the convention provides a list. So you can say the contract was invalid, you didn't get notice of the arbitration, the dispute itself wasn't covered by your arbitration agreement, the arbitrator was not appointed properly in accordance with that agreement, the award is not yet final or has been set aside at the site of arbitration, the subject matter of the arbitration itself is not arbitrable, or, and this one is somewhat interesting, the award is against public policy of the country where enforcement is sought. So not only does the convention say we are going to recognize and enforce international arbitration awards, but we will also enumerate reasons and specific circumstances in which you can seek the non-enforcement of that award. And so, in keeping with the New York Convention, questions often come up about when is an arbitration actually international. And I think what's perhaps most important about this question is that technically an arbitration could be international even if the parties do not necessarily expressly intend it to be. And so looking here at the UNCITRAL model law, which the US has adopted, it outlines when an arbitration could be international. And so you have instances where the parties to the agreement have their places of business in different countries, or if one of the three following items there under some point B occur, if one of those subpoints happens outside of the state in which the parties have their place of business, so the place of the arbitration itself, where a substantial part of the contract obligations are to be performed, or a place most closely connected to the subject matter of the dispute. And then C, there you have the parties expressly agreed that the subject matter of the arbitration agreement relates to more than one country. But I think the biggest takeaway is that you have an outline for when an arbitration can be international. And perhaps most importantly, the parties themselves may not even recognize that their arbitration is international. And there have been instances in which parties have gone to, for example, the AAA to arbitrate in what they think will be a run-of-the-mill domestic AAA arbitration, and AAA says, no, you're going over to the ICDR. This is an international arbitration, and even though you may not expressly have said as much in your agreement, it's quite clear to us this is international in nature. So you've got to be aware of these components, particularly in the modern global economy, because it's actually not that difficult to fall into one of these exceptions or bullets up here on the board. And so you may actually have an international arbitration without necessarily expressly recognizing or otherwise agreeing to that per se.
To set the table on some of the discussion that's going to follow this, there is a real difference between the viewpoints of Americans and people overseas with respect to the law, the way arbitration proceedings proceed. And we've outlined some of these here. In the United States, we have notice pleading. We had a contract, you breached the contract, you owe me damages, that's sufficient to state a claim. If you look at the AAA form for initiating an arbitration, it just has a blank, what's the dispute about? Breach of contract. That's sufficient to invoke a proceeding. In a United States proceeding, you're likely to get at least some discovery because arbitrators tend to be former lawyers or active lawyers, and they have been brought up in a legal system where discovery occurs, and so they're used to that. The common law systems place a heavy reliance on witness testimony and vigorous cross-examination of those witnesses to bring out the truth. In a U.S. arbitration, there's less strict adherence to rules of evidence, to the federal rules of evidence or the state equivalent. And questionable evidence often comes in with the arbitrator saying, oh, don't worry about it, it's going to go to the weight. And the reason that they say that is when you go to the Federal Arbitration Act and the state acts, it talks about the refusal to accept evidence as being a grounds for vacator. And so the arbitrator will say, I'm going to let it in, and then they just ignore it. In a civil law system, typically the pleadings are fact pleading. It's not enough to say breach of the contract. You have to say how they breached the contract and what provisions were violated by that activity. If you get discovery at all, it's going to be limited to document production. Also, there is more of a reliance on contemporaneously created documentary evidence than there is on witness testimony. And the reason for that is culturally, they believe that witnesses are unreliable. In fact, the ICC has commissioned a 64-page study along with references to scientific papers and other things on the accuracy of fact witness memory in international arbitration. And what this document says is, well, witnesses, they alter the events just simply by retelling them, right? They implant in their minds, different facts than actually occurred. Events that happen before or after the event can influence their testimony. The way people question them can influence the answer. And that's before you even get to the question of whether the witness has some kind of bias or prejudice in giving his testimony. And so that's one of the big differences in international is there's much more emphasis placed on what do the project documents say as opposed to what do the witnesses say. So one of the initial drafting issues that you have to address is whether you were going to have an ad hoc or unadministered arbitration, or whether you're going to have an administered arbitration through one of the arbitral bodies that are out there, and there are a lot of them. This is probably 1% of all the different service providers that are out there across the globe. So people generally do ad hoc, and that typically is done under the UNCITRAL rules. And the reason that they do it is because they think they're going to save money on the fees, the administrative fees that have to be paid to the arbitral institution. You really don't typically save a whole lot of money, because what will happen is at the first preliminary conference, the president of the tribunal will say, well, you know, I really need help with this, and so I want you to agree to hire my secretary at a small hourly fee to do all of the administrative work for the arbitration. And so you end up paying for it just in a different way. The other problem with ad hoc arbitration is that you don't have anybody to complain to. You know, if you think the arbitrator has to be disqualified because they're biased, you don't have an organization to go to register your complaint. Who do you have? The arbitration panel to which the allegedly biased arbitrator is a member, and that's not, that's not great. So, I think administered typically is the preferred way to go. And as the slide shows you, there are a variety of different institutions out there. The rules are similar, but they have some subtle differences, and you need to pick the organization that you think best fits your project. And I think that takes us to the next one. Yes. So, this is a very, very simple clause that any dispute is going to be determined by UNCITRAL arbitration. This kind of clause leaves definition of the proceeding, what the arbitration is going to look like procedurally, to the rules, and also to the tribunal's discretion with party input. One other thing that I want to point out about this particular clause is that any dispute, controversy, or claim language, that language delegates to the arbitrators questions of arbitrability, what disputes are arbitrable. As a general rule, arbitrability questions in the United States would go to a court. But the Supreme Court has ruled that if there is an a clear and unmistakable delegation of arbitrability to an arbitrator, then that goes to the arbitrator. And you saw, if you were reading in the paper earlier this week, the Tiger Woods' ex-girlfriend was trying to get out of her arbitration agreement, and the judge was like, well, why are you here, right? Well, the signature's for it. She says, well, that's a decision for the arbitrator. That's not my decision. And the courts have also held that as soon as you invoke the institutional rules of a particular provider, a AAA, ICC, ICDR, LCIA, whatever, that is clear and unmistakable evidence of delegation of arbitrability to the arbitrators. Why? Because all of those sets of rules have provisions in it that say that the arbitrators have the authority to determine the scope of their jurisdiction, and they also have the authority to interpret the arbitration agreement. Excuse me.
And so with that in mind, I think it's worthwhile to go over a couple points in housekeeping issues with drafting your international, or frankly, many of these apply to your arbitration clause. And one of the first bullets we have up here is pre-arbitration requirements. So you're going to have something like negotiations between commercial representatives. Are you going to have mediation? Are you going to have other conditions precedent that must be satisfied before you move forward to arbitration? And while I'm here and while I have this platform, I will say, please always put an end date to when you have to mediate before you can go to arbitration. Otherwise, people will drag it out ad nauseum, and your client will be sitting there yelling at you about why can't I go to arbitration now because they refuse to engage meaningfully in mediation. So if you're going to have conditions precedent, put a date by which they have to be satisfied. Otherwise, you can go ahead and move forward to arbitration so that you don't have to deal with somebody intentionally dragging those proceedings out. The scope of the issue subject to arbitration, I mean, Rich touched on this a minute ago, but are you going to expressly carve something out, like the arbitrability of the dispute to begin with, or something like equitable relief? We see that fairly frequently, that if I want an injunction, I get to go to a court, but otherwise, we'll handle our run-of-the-mill construction disputes before the arbitration panel. So consider what you might want to carve out of your arbitration agreement. Selection of arbitrators. This becomes an even bigger issue in international arbitration. I mean, you have your standard issues like, how many arbitrators will you have? Will there be one? Will there be three? Or are you going to have some other number? And I think that's fairly standard across international or domestic. The process for appointing those arbitrators, there are a number of routes you can go. I mean, you can expressly state in your arbitration agreement, here's how we're going to select the panel. Each parties will nominate one person, and then they'll get together and nominate a panel president if you have three, for example. Or are you going to leave it up to the body administering your arbitration and just allow them to set and appoint arbitrators as they see fit? I wouldn't necessarily recommend that. I think you have much better control over the process when you expressly say, here's how we're going to select arbitrators. But nonetheless, sometimes parties aren't as specific. The nationality of your arbitrators is particularly important within international arbitration. And there are a whole host of legal, practical, and cultural issues that go into the selection of the nationality of your arbitrators. I mean, if you, for example, select 3 arbitrators sitting in Texas for your ICC arbitration, it is quite likely that they may still have an American system of litigation embedded into their minds, and you might start saying things like depositions in your ICC arbitration. And I have seen that before. But if you go to Paris, Prague, and Brazil and select 3 arbitrators from those locations, they are much more inclined to adhere to something resembling the civil system. And so the nationality and selection of arbitrators, I think, is a great example of where you start to see the conflict and the confluence of international and domestic arbitrators. Qualifications of your arbitrator. Do you want someone who is a quote-unquote arbitration expert? Probably. Do you want someone who's an industry expert? Yes. I mean, the answer is yes. How you go about establishing those qualifications, though, is entirely up to the parties. I mean, I've seen clauses that say this person must have had X years of experience in the construction industry, or be a member of the College of Construction Lawyers, or any number of objective criteria that you can use to qualify an arbitrator. But you want to make sure you have somebody that's qualified to hear your complicated dispute. And the last one may seem somewhat rudimentary, but you want to be very clear about language proficiency. And Rich and I were actually talking about a case in which there were a number of issues with language proficiency. You had an arbitrator who wasn't necessarily fluent in English. You had another party who was speaking and writing almost entirely in Korean, and then you had another party who didn't understand what the other 2 parties were saying. And it was a Tower of Babel situation, frankly, where nobody knew what was going on. The whole thing was a mess and a disaster. But nonetheless, no one had thought about writing into their arbitration agreement, everybody needs to be able to speak English, or the arbitration proceedings will be conducted in Spanish. Whatever it may be, you need to say what the language of the proceedings will be so that you don't wind up in a facially preposterous situation in which nobody knows what the other party is saying.
Before I talk about this next slide, I do want to talk about the carve-out issue for just a second. And it is critical that if you carve out issues, that you do it precisely and with great definition. And I'm just going to give you the case of Archer and White Sales versus Henry Schein, which had a very poorly drafted carve-out provision. And the parties spent 8 years and 2 trips to the Supreme Court to determine who was going to decide what issues were subject to the carve-out and which ones were not. And so you just need to be very, very precise. To pick up on the last point from William, some of the issues that you would deal with would be the language of the arbitration, the location of the arbitration. And these next 3 items are things that you need to pay attention to, because in international arbitration, they differentiate between the place of the arbitration, the location of the arbitration, where the physical place where the hearings are going to be held, the seat of the arbitration, which is the place that supplies the procedural law applicable to the arbitration proceeding, and then governing law, which is what law is going to apply to the interpretation of the agreement and also to the resolution of the dispute. And sometimes they are all the same, and sometimes they are not. But the seat is a particularly important issue because arbitration, the way the law works here, the Federal Arbitration Act applies to interstate commerce. Construction projects are almost always interstate commerce. But the state acts also apply to the extent that they are not in conflict with the FAA. And that raises some interesting issues because depending on what state you're in, the arbitration law may or may not allow for discovery. Texas does. Louisiana does not. If you're in a state that's adopted the revised Uniform Arbitration Act, those states may allow for discovery. So the seat is very important. The governing law is also important because it sets what the claim requirements are. We were talking earlier this morning about whether notice is required or whether substantial compliance is required. Texas is a substantial compliance state. New York is a strict notice state. If you don't give notice in accordance with the terms of the contract, you are dead. And that's just the way it is. So governing law is important. Confidentiality is important. I mean, people have this conception, well, I'm in arbitration and therefore everything is confidential. No. Arbitration is private dispute resolution. The rules, if you look at them, say that the arbitrators and the arbitration institution are going to keep things confidential, but there's no requirement in any of the rules that the parties keep it confidential. And so you need to write that into your contract. Consolidation and joinder issues are things that you need to look at, and rules of evidence, whether you're going to have discovery, you can write that into your contract, whether there will be or will not be discovery.
And kind of to close the loop on some of these drafting issues, in addition to everything Rich and I have already talked about, think about the end result, the award. What do you want that award to look like? And many of the forums that we've identified and discussed have rules that impact somewhat the form and substance of the final award, but the parties are really the masters of their destiny. And they can say in the contract itself, here's what I want my award to look like. So what do you want the form of the award to look like? It's just going to be a standard award? Will it be reasoned? Do you want findings of fact and conclusions of law? All of these things can be taken into consideration and included in your arbitration agreement. And I think the overall point is that you have a lot of flexibility to do that. Are you going to have a time limit for your award? I think many of the arbitration forums internationally have time limits to issue an award, but that doesn't stop you from nonetheless putting something into your arbitration agreement that says, look, I don't want to wait 2 years for a well-reasoned award. I want you to go ahead and get it done so that we have a result, because that's what we're paying you to do. And lastly, what appeal rights might you have? In addition to what may or may not exist under various conventions and statutes and treaties, are you going to write something into your arbitration agreement that addresses that? What would be the forum for an appeal of an international arbitration award, if there would be one? So there are a whole host of things to consider. Particularly within the international context when you're preparing your arbitration agreements. And so we would caution avoiding the simple clause that Rich had up several slides ago and take into consideration a lot of these other issues.
And I think one important point to be made is that people pay little attention to these dispute resolution clauses until there's a dispute. And you really need to pay attention to them at the front end. And read through it and understand what you're signing up to do. There are multiple drafting aids out there. The IBA has guidelines, ICDR has guidelines. There's a section at the back of the ICC rules that has suggested language. JAMS has a clause workbook. The LCIA, the London Court of International Arbitration, has some website with some guidelines. But the one that I've left for last, which I think is going to be most useful to you guys, is that AAA on their website has a tool that's called the Clause Builder tool. And so you go onto the adr.org, and up at the menu bar it says clauses, and then you'll get this sheet that describes, arbitration clauses, and there's a link in there to the Clause Builder tool. And it is an interactive website that starts off with, what kind of clause do you want, right? And you click arbitration and mediation, and then it says, how many arbitrators do you want, 1 or 3? And then there are other options on the sidebar where you can say, well, I want qualifications. I want this kind of language proficiency. And so there's this whole list. And after you've clicked all the buttons, it spits out a Word document that you can take and then modify some more to incorporate into your contracts. So, we're now going to talk a little bit about, in the international context, there are rules, which are the rules that are promulgated by the arbitral institutions, and they tell you how you initiate an arbitration and what the procedural steps are leading up to an award. But the rules don't cover all of the issues that typically come up during an arbitration. And so there are things that are referred to as soft law, and the one that's the best known is the IBA rules for the taking of evidence in international arbitration. And the IBA rules address things like the production of documents during the arbitration, how you handle witnesses of fact, how you handle party-appointed experts, how you handle tribunal experts, inspections, site inspections, and how you conduct the evidentiary hearing. And these are typically not resorted to as hard and fast rules. What you'll see in a procedural order is that the tribunal and the parties agree that the IBA rules will be a guideline for the conduct of the arbitration proceeding.
And speaking of the conduct of the proceeding, I think it's important to kind of set the context for what your general procedure is going to look like in your average international arbitration, because there are some key differences that exist internationally versus domestic. And I think it's worth highlighting some of those, because these should be taken into consideration when you're drafting your arbitration clause or sitting there saying, will this potentially be treated as an international arbitration? And so international arbitrations almost all have what is called the procedural timeline. And frankly, that's really no different than your scheduling order in federal court. But it outlines when key events are going to happen. And so, if you look down the events that are listed up there, some of those are near and dear and obvious to domestic arbitration. So your request for arbitration, your answer and counterclaim, your preliminary procedural conference. All of those things kind of run the same. But you really start to see divergence within your procedural order of events when you get to the terms of reference. And we're going to talk about that in more detail in a second. But essentially, that is your arbitration rulebook. It sets the issues that are going to be arbitrated, who the arbitrators are, and what is before the arbitration panel for final decision. You have the memorials, and Rich is going to talk about these in depth here in a second, but these are fundamentally different, these memorials, than what you see in a domestic arbitration. And that includes your statement of claim, your statement of defense, your statement of reply, and any rejoinders. And so your procedural timeline is going to say, okay, here's when the parties need to file these documents. And again, we're going to get into the substance of these, but this is generally what the timeline is going to look like. Request for production, like Rich already mentioned, discovery is handled much differently in an international arbitration. So your procedural timeline is going to address, what sort of document production is going to occur, what methods will be used, when do you have to file, the tools, which we'll look at in a second, to use to request and produce documents and things of that sort. And then when will your merits hearing occur? And again, we're going to talk about this, but the merits hearing itself internationally is going to look different than your traditional AAA arbitration, for example. But your procedural timeline needs to take all of that into account. I mean, when are you going to have your hearing? How many days is it going to be? How are you going to handle all of your witnesses? And then it's going to have potentially a date for a final award, or a date within which everybody's going to work to have their final award. And that may come from your arbitration agreement, that may come from the existing rules, or it may just be something that the parties agree to when they put together their procedural timeline for the case. And as promised, we're going to talk a little bit about some of the substantive issues within that procedural timetable that are different and look different than domestic arbitration. And I think one of those is the terms of reference. And that's a document that you don't really see in domestic arbitration or AAA arbitration. And what it is essentially is a document prepared collectively by the parties and submitted to the panel for approval and signature that defines the dispute. It says here are the claims that are at issue, here is what we are fighting about, and here is what we wish to put before you, the arbitrators, for decision. And in many ways, too, it also memorializes the jurisdiction of the tribunal itself and says this is what we put before you for decision. And typically, that document's going to identify the parties, the arbitrators, the claims, the rules. So are you going to take the IBA rules of evidence, for example, that soft law, and make it into the applicable law for your case through the terms of reference? You're going to identify the issues to be resolved, and you're going to identify your place of arbitration. So it is kind of like the rule book for your arbitration that goes beyond just whatever procedural rules may exist and apply. There are several, I think, very important main consequences to your terms of reference. So it's important to actually put a lot of thought into this, particularly when you're crafting the claims and issues that are before the panel for resolution. Because the terms of reference are going to limit the claims that you can present to what's actually identified in that document, absent further authorization from the arbitrators. So if you want to come back and assert additional claims later, you're going to have to go to the panel and ask them if it's okay, and then you're going to have to amend your terms of reference. Otherwise, it's not an issue before the panel for decision. Conversely, or on the other side of that coin, the arbitrators are bound by the terms of reference to actually resolve the claims that are presented to them as identified in the terms of reference. So they have to sit there and check the box that they have resolved all the claims and issues that are contained in that terms of reference. And again, importantly, that document, as shown in the last bullet point there, it's going to bind everyone to the identified procedural rules. So everybody is starting from the same place and working from the same rules. Anecdotally, we encountered an instance, or I saw an instance once, in which there was an owner with a multi-prime contractor situation. One of the multi-prime contractors was a supplier of mechanical equipment that derailed the entire project schedule. So other prime contractors sued the owner. The owner then turned around and sued the supplier, and everybody wound up in ICC arbitration together. And initially, all of the primes had pointed their fingers at the owner and said, you're at fault. Well, 2 days before the arbitration hearing, the owner settled with one group of primes. And they all showed up at the arbitration hearing, and everyone pointed their fingers at the supplier. And for 2 weeks, every single attorney that represented someone other than the supplier got up to the podium and just hammered the supplier's witnesses. I did not feel bad for their attorneys, but it was a horrible, horrible experience for them. Everyone walked out of there saying, that was great, we're going to get so much money. Well, the panel came back in their award after much scrutiny by the ICC, and they said, I'm sorry, that wasn't in the terms of reference. You guys were supposed to all have claims against the owner and try to figure that out. No one was supposed to settle those claims and then all gang up on the person left out in the cold. And so there was a severely limited award that was actually granted. Now, I think the panel left open the idea that these other parties could essentially refile and finish out their claims, but the panel said, I'm sorry, this wasn't in the terms of reference, and you didn't ask to change the terms of reference. And it had a huge, huge consequence and impact on that arbitration.
So we're going to talk for a minute or two about what are referred to as memorials. And I think one of the substantial differences between international and domestic arbitration is the idea that the parties present their cases on paper before you ever get to the merits hearing. And the consequence of this is in the conduct of the hearing, you're not really going to get direct examination. The witness gets up and he says a few words, and then you go directly into cross because they have proven their case on paper and given the direct evidence on paper. So there are 4 types of memorials, as William said just a minute ago. There's the statement of claim, where you flesh out for the tribunal what your claim is. You have a narrative document that says, here are the facts, and here's the law, and this is why we are entitled to recover. The statement of claim would be supported by witness statements, basically declarations of the witnesses saying, these are the facts, they all feed in and tie together with one another. So the witness says, here are the facts, and those appear in the statement of claim. And then the witness says, and here are the reliance documents that prove that what I've said in this witness statement are correct. It is an enormous and expensive undertaking to put one of these together in a large case. So pointing back to the witness statement, if we could go to the next one. So the witness statement provides the direct testimony, the facts that support the claim. When you get to the hearing itself, as I said a minute ago, there's very little or no direct examination of the witness. You might have 5 minutes or 10 minutes of introduction so that the tribunal can see that this is a warm body that actually is capable of speaking to them. But they're not going to give the testimony that's in the witness statement. The purpose of the witness statement, it reinforces the documentary evidence that's presented. It provides context for the documentary evidence. It might talk about the project controls program that they had in place and who did what. That's not necessarily evident from the project record. You can fill evidentiary gaps in these witness statements. For example, if there was some undocumented conversation that's important to the outcome of the case, you can provide technical explanations. And the objective here is, without direct examination, you reduce the time of the hearing, and you might also reduce the need for document production because people are required to produce the documents that they are relying on. And we were talking about the soft law earlier. If you go to Article 5 of the IBA rules, they give specific item by item what needs to be in a witness statement: the name and the address of the witness, their relationship to the parties, their background and qualifications if it's relevant, the facts that they know and the source of the information, what their language skills are, and then they need to sign an affirmation that their witness statement is true and correct, and then they also have to sign it. So we have a case in the office right now where we have just completed the statement of claim phase of the proceeding. That is our opposing party's statement of claim. That is their narrative, 3 witness statements, and 3 expert reports. It tops out at somewhere over 900 pages, and that does not include the 1,400 exhibits that they submitted in support of their claim. As I said before, this proving your case on paper is a massive, massive undertaking.
Yeah, and so piggybacking off of the picture Rich just showed, that is a huge fundamental difference between domestic and international arbitration. You are, in essence, proving your case through a stack of papers. And what you may have noticed from the procedural timeline that we had up there earlier is that document production requests tend to fall after all of your memorials are due. So the idea and the expectation is that you as a party can totally prove up your case with what's in your possession. And that comes from a number of different, European civil law traditions, but one of those is, frankly, you don't have an absolute right to document production from an opposing party in international arbitration. And there, at least in theory, is absolutely no American-style discovery, where everybody shows up and says, I'm entitled to the production of every document that's reasonably calculated to lead to the discovery of admissible evidence. It is not like that at all. So you really do see the civil law influence. So when you're working through requests for production in an international arbitration, you are fairly limited in what you can ask for and what you can expect to receive. So you can ask for documents or narrow categories of documents, but they must be identified in a specific manner. So you can't just say, give me all of your project communications. You have to actually identify very discrete and very specific items that you want. And those items cannot be in your possession already, which again, I think is fundamentally different from what you frequently see in America. You also have to prove that the items requested are relevant and material to the outcome of the case itself. And so that is significantly more limited than what you would normally see in your American-style discovery, where it's just, I think something may be admissible, I'd like to see 1 million documents, please. The Europeans aren't going to allow that, and we see that coming over to America as more and more arbitrations are conducted within these international forums. And as a final bullet there, the document request can't be overly burdensome to the producing party. The civil and American law systems have very different ideas of what is overly burdensome. 10 documents may be overly burdensome to a company from France, whereas 10 million documents may be overly burdensome to your typical American company used to litigating here. So while, yes, overly burdensome is one of the categories, just understand and know it is not viewed the same as it is in a federal or state court here in America. So Rich and I kind of distilled some guiding principles for document discovery in international arbitration, and that's specificity, relevance, materiality, and proportionality. And that covers those bullets we just went through, but the whole idea is that you are going to be very specific, very targeted, and very narrow in your document requests, and the corresponding production in response to that is going to be similarly limited. How do parties normally actually go about doing that? Well, you typically do not see what we would call a request to produce in America, where you get the list of things you want. Typically what's used is something called a Redfern schedule. And I've put an example up here on the projector. And essentially it's a giant Excel sheet where you identify the document requested, you identify the reason for that request. The other party then in this same document says, here's why I object to that request. Then the requesting party comes back and says, here's my reply to your objection. And then it all goes before the tribunal and they issue their final decision out there. And this process plays out over a number of weeks as this Redfern schedule is circulated back and forth amongst the parties. And I will say, when you see one of these filled out, it is an overwhelming volume of information. And it often stretches far, far out to the right of the page, because you can't just say, for example, give me your project emails. You have to say, request number 1, I want the project email that is referenced in your statement of claim from December 11th, in which Bob said X. I don't have that in my possession. You reference it. I'd like to see it. And then you have to explain why it's relevant and narrow and material to your case and all that. And so all of this information winds up in your Redfern schedule and is circulated amongst the parties. So it looks, feels, and sounds very, very different from your typical document production process in domestic arbitration or domestic litigation.
So we're going to address very briefly the topic of electronically stored information. In the international framework, the same rules apply to ESI production. It's got to be specific requests. It has to be relevant and material to the outcome. The request has to be proportional. And I think one of the big battlegrounds, and we're actually arguing that now in a case, is whether the request has to be relevant and material and specific, or do the documents that are the result of that search have to meet that standard, and how are you going to determine that? So to lead in, electronically stored information is fundamentally different than paper. And that is part of the problem. I mean, I'm old enough that I remember that the first case I worked on, everything was on paper. And back in the old days when dinosaurs roamed the earth, if you had a project memo and you wanted to send it out, well, you had to go to the photocopy machine and run off 20 or 25 copies, for which there was a charge. And then you had to stick them in inner office envelopes, and then you send it out. Well, today, you have an address tree that's 100 people on it, and you attach the document, and you hit send, and now there are 100 people who have this document, where before it might only be 10, 15, 20. ESI is stored in multiple places. It could be on your local computer, it could be on a server, it could be off in the cloud, it could be anywhere. It has a dynamic quality that you open the document and the metadata changes. There's hidden information, formulas in Excel spreadsheets. There are electronic documents that are dependent on the system that creates it, Primavera schedules, for example. And deleting the document from your local computer doesn't necessarily mean that the document has gone away. It can live on a server or somebody else's computer.
And so what we've seen, or what we see emerging, is a collision with the traditional international arbitration idea that your document requests are going to be very specific, narrow, and tailored, which you see there in IBA Rule 3.3. I mean, you're looking for material, relevant, specific, and something not in your possession. Well, ESI is not treated any differently, yet ESI is fundamentally different. Because how can you develop ESI search terms that are narrow, specific, targeted, and tailored, yet nonetheless are applied to millions of documents and will return inevitably hundreds of thousands, if not millions of hits? And so in theory, your ESI production in international arbitration is still subject to all of these requirements, but in practicality, you see a lot of conflict within the arbitration itself and among the parties about how to reconcile these differences and this clash of cultural ideals and ideas. And Rich was referencing that a second ago, and it is becoming an ever-increasing friction point within arbitrations. Now, and I'll close by saying that there's some IBA commentary that says the rule recognizes that some relevant and material documents may not be capable of specific identification. Well, that's more or less the exact opposite of what the IBA rules want you to do. So the IBA itself is trying to straddle this line of, okay, it'll be specific and tailored, but yes, we live in a modern digital world where your average large project can create an absolute mountain of ESI. And how do we reconcile that? You'll have these materials when you leave, so I won't go through each of them, but there's a whole host of ESI resources that are out there. And these are incredibly useful tools if you find yourself in an international arbitration fighting over document production, ESI collection and production, and all of those things. So understand that these secondary sources are out there. And I will say that there is a fairly large lack, if that's the right way to describe it, of case law regarding discovery in international arbitration, or frankly, anything in international arbitration, because it's largely unreported and not subject to appeal. And so for those reasons, secondary sources really play a key role, and we frequently see them relied upon in these sorts of disputes.
So when you get to the merits hearing, the typical way that you would do it is the claimant puts on their case, the respondent puts on their case, and then there's a rebuttal, and then you're done. International arbitrators have considerable authority and discretion over how they conduct the proceeding. They can impose chess clock hearings over the objection to the parties. Chess clock is where you take the total hearing time, you divide it in half, you get half, and you can use it any way you want. You get half, and you can use it any way you want. But when your time is up, your time is up. you can have time-limited examinations. We were in an arbitration, Chris and I were in an arbitration where the arbitrator said, okay, here are the witnesses. How much time do you need for cross-examination? I said, I want 4 hours with this witness. And the panel said, no, you get 2. I want 3 hours. You get 1.5 hours. So they have authority to do that. In that same arbitration, the arbitrators dictated the way the case was presented to them. We had 7 days. We did them 7 days consecutively. And the way the witnesses were presented, they did all the C-suite guys on the first day. They did all the project manager types and those folks on the second and third day. They did boots on the ground people on the fourth day. They did third-party witnesses the next day. And then we had 2 days of expert testimony. And they dictated who testified when and in what order. They can order witness conferencing, which is where you take 2 experts and you bring them in, and they both get examined at the same time. So they have a very wide authority for what they do.
And I'll be quick because I know we're bumping up on our lunch hour, and the last thing I want to do is keep a bunch of hungry people from what looks like a great meal. But I will say there's a couple things to point with the award itself. The New York Convention says it must be in writing. That's not all that surprising. The institutional rules for many of the arbitration panels have your requirements that the award must meet, and those are all laid out in there, and those are fairly common to all of the institutions. It needs to be in compliance with applicable law at the seat of arbitration, and this is an important note. ICC awards are scrutinized by the ICC Court of Arbitration, which means once the panel finalizes their award, it gets sent off to Paris or New York, and a group of people there scrutinize the award, and oftentimes it can take months for them to scrutinize the award to make sure it's all done according to their rules and requirements. So the award itself is governed by a number of laws and rules.
So we've got some slides in here that I'm not going to cover because we've run out of time. They govern confirmation of the award, vacating the award, and modification of the award under the Federal Arbitration Act. Just suffice it to say, the big takeaway there is the grounds for vacating and modifying an award are extremely, extremely narrow. And so awards typically are not going to be overturned by a court. And then if you go to we also have included before that, well, we have a slide in there that has some resources that are available. The Bourne Treatise is the gold standard, but you have to purchase that. It's a 4,000 page or something like that, treatise on international arbitration. But there are other resources out there that are easily downloaded off the internet. You've got ICC has publications, so does the IBA. ICDR, which is the International Center for Dispute Resolution, which is the international arm of AAA, and other resources are available. Which brings us to our last slide.
Yeah, and just to put a bow on everything, that first bullet there, arbitration will and is going to continue to be the preferred process for the resolution of international disputes, and for all the reasons we already discussed. Enforcement issues, as well as the simple fact that non-U.S. parties are terrified of U.S. courts and terrified of anything with the word American in it.
I think you're also going to see that what you've seen over the last 10 years is that American arbitration proceedings have been adopting features of international proceedings like the chess clock. And the international proceedings have sort of been creeping closer to what we would call a domestic outlook on the proceeding. I don't think that they're ever going to meet in the middle. There's always going to be a gap between them, but everybody is sort of adopting best practices from each other.
And then with our third kind of observation here, look, the fact of the matter is arbitration is very expensive. And even when you try to limit it, as international arbitrations do, it doesn't change the fact that it's not cheap to get in and get out. And so you do see an increasing use or attempt to use ADR procedures to avoid arbitration altogether. So project neutrals, DRBs, dispute adjudication boards, mandatory negotiation, mediation, other things like that. So people are acknowledging the high expense and trying to get off the ride before it becomes too burdensome.
And then I think the last point that we have is that ESI is going to continue to be an issue, and it's only going to accelerate. I was at a meeting where a representative of a company was talking about having employees, construction employees, wear wearables while they're on the job site so that their movements can be tracked. And they do it for safety reasons, they do it for productivity reasons, and that sort of thing. And so the amount of data that's going to be available out there is only going to increase. It's not going to decrease. And the funny story out of the wearables was the guy reported that the safety guy comes in and says, geez, this guy, one employee, 5 times a day, he has a 15-foot fall. And they bring the guy in and they question him about it, and it turns out that, he would go from the 19th to the 18th floor by sliding down the banister on the railing. And so he was going at a higher speed, and then there was an impact at the bottom, and but that's all that data is going to be available. And on the subject of data, and I know we've run out of time, both as an advocate and as somebody who does work as an arbitrator, if you think you have claims, you can help yourselves and your lawyers and the arbitrators out by keeping really good records. I can't tell you how many times I've seen people who have a productivity claim and they hand me the daily report, and the daily report says, we was interfered with by X. Okay? And all it takes is another minute and a half or 2 minutes to write, we were interfered with by X, and because we were interfered with, we had to demobilize, and we had to move to another location, and we had to remobilize, and the crew lost 6 hours of productive time. That's really helpful, but we very rarely see that, and it becomes really difficult for lawyers and fact finders to present a claim or evaluate a claim without that information. So that's just a takeaway. Thank you.
Thank you.
Thank you.